first stuff here is housekeeping and stuff. So um, let me begin by saying that my name is Joe Liu. I'm president and CEO of the Coalition for Clean Air. And you might hear us refer to Coalition for Clean Air as CCA. Thank you for joining me today for our Clean Air Conversations webinar about California's Clean Air Act Authority and all things waivers. At Coalition for Clean Air, our mission is to protect public health, improve air quality, and prevent climate change. And you can find out more at our website, ccair.org. We're a nonprofit public interest organization. We depend upon your charitable contributions to pursue our mission. So please make your charitable contribution at ccair.org. And thank you for your support. Today's webinar and the continuing legal education CLE credits have been made possible through our partnership with the Greenberg Glusker law firm. So thank you to Sherry, Sadina, and everybody else, and Anne from Greenberg Glusker, who's joined us here today, and others, and for supporting our event and making this all possible. For those of you joining for CLE credit, we will provide details how you claim your credit, and we get all that taken care of at the end of the webinar. If you are an attorney who would like CLE credit for this but didn't sign up for CLE credit, get in touch with us. Probably Jordan, maybe you can. We'll figure it out. Get in touch with us, and we'll figure out how to get you that credit. Here's what to expect this morning. I'll be reviewing a few housekeeping items, and then we'll be talking to you about the Clean Air Act and California's efforts to protect its authority to regulate emissions from mobile sources. And mobile sources are cars, trucks, off-road equipment, hovercraft, ships, and most locomotives, almost anything that moves within California's jurisdiction. So we'll start with a review of the history of the challenges to the California's Clean Air Act Authority, learn about how Congress and the Trump administration have used the Congressional Review Act to revoke regulations adopted by California and under this waiver issue. And we will hear about the interesting possibilities should the Trump administration follow through on their proposal to revoke the greenhouse gas endangerment finding. And that greenhouse gas endangerment finding provides the legal basis for the U.S. Environmental Protection Agency's regulation of greenhouse gases. And after that, we'll shift to a moderated, facilitated conversation among our presenters and me before we conclude by answering questions that you post in the chat. So at least to the best of our ability, and as time allows, we should have time for Q&A. If there's a question you see in the chat that you think is particularly important and want answered, click on the thumbs up icon to promote it, and we're going to prioritize those ones that get the most promotion. If all goes well, and I'm sure it will, we'll conclude at 11 o'clock. Some of these issues can be very complicated, and those of us who are members of the air quality tribe, I think we all use more acronyms than any subspecies on the planet. So if we don't explain those acronyms, or if we lose you because we failed to explain something well enough, let us know in the chat, and we'll try to make sure that you can follow along. Now for the housekeeping items. We're recording this event. We'll post it on YouTube and our Coalition for Clean Air website. You should know that there may be members of the media in the audience today. I didn't see any on the list, but if you're a reporter, we ask that you not quote anyone without first getting consent, and we thank you for respecting that request. Please keep your mic on mute unless you're one of our speakers. We have staff who are there and ready to mute you if necessary, but it's better if you do it yourself. They'll also throw you out of this webinar if you misbehave, so don't do that either. We use this format instead of the other webinar format because it allows everyone to access the chat and send private messages to each other. So please take advantage of that. Say hi to your friends and create chats between your friends or among your friends. Also, don't use the raise hand function if you have a question. Pretend that function doesn't exist. We're only going to be taking questions from the chat. So if you have a question, just put it in the chat and we'll see it there. That's it for housekeeping. So let's get on to the substance of this. We have two amazing people here with us today. We're very privileged to have them. First up will be Ellen Peter, former Chief Counsel of the California Air Resources Board and the 2025 Lifetime Achievement Award recipient from the Environmental Law section of the California Lawyers Association, which I still think of as the California Bar Association. But Ellen spent 17 years, I'm sorry, 17 years as chief counsel at the California Air Resources Board and 23 years with the California Attorney General's office. It is great to have her here today. We also have Professor Ann Carlson, who is the Shirley Shapiro Professor of Environmental Law and a faculty director and founding director of the Emmett Institute on Climate Change and the Environment at the University of California School of Law. UCLA, go Bruins. I probably shouldn't have said that because I know Todd Campbell's attending. But anyway, from 2021 to 2024, Ann served as chief counsel and acting administrator of the National Highway Traffic Safety Administration, known as NHTSA, for the Biden administration. Thus, she, like me, is bilingual. She and I both speak air quality and transportation. But unlike me, Ann is the author of Smog and Sunshine, the surprising story of how Los Angeles cleaned up its air, which is set to come out in April 2026. I can't wait to read it, and I hope you join me in that. We'll be starting with Ellen, who will remind us that this isn't the first time we've faced challenges to the unique authority of the state of California to adopt air quality regulations that reduce engine and vehicle emissions. So I will turn it over to Ellen.
Thank you so much, Joe, for inviting me to be part of this webinar. So, although many of you are already deep in the weeds of these issues, let me start with an overview. What is a waiver, and how do waivers fit into the Federal Clean Air Act landscape? So, after World War II, the air quality in Los Angeles deteriorated rapidly. People were getting sick, the mountains were lost in the haze, couldn't see them, they were invisible, and agricultural products were damaged. Initially, the cause was unknown, but a Caltech chemistry professor, Dr. Ari Haagenschmidt, figured out that the tailpipe emissions from the ever-increasing number of cars, combined with Los Angeles hot sunshine, produced photochemical smog, which was trapped against the mountains by the temperature air inversion. In short, cars was causing the choking smog. In about 1947, Los Angeles County was the first to try to control air pollution. Later, the state stepped in with several agencies working to solve the problem. However, the smog got worse. So then there was bipartisan support for more comprehensive control of air pollution from cars. Then Governor Ronald Reagan signed legislation in the summer of 1967 to establish the California Air Resources Board. He appointed Dr. Haagenschmidt to be the first chair of the board. And then the state regulations accelerated. Meanwhile, at the federal level, Congress was considering national federal standards to regulate air pollution. A key issue was what to do with the existing California regulations. There was an intense political fight with strong opposition led by the auto industry. In 1967, George Murphy, the Republican U.S. Senator from California, proposed an amendment to allow California to continue its regulatory efforts. He argued that Los Angeles faced extraordinary and compelling air pollution challenges. His amendment was successful. However, the other states were preempted from setting air pollution standards, but Congress said California shall receive a waiver from preemption unless there was an evidence to support a denial on three very limited bases. So this California exception approach then continued into the Federal Clean Air Act of 1970 with the newly created U.S. Environmental Protection Agency in charge for issuing California's preemption waivers. The 1977 Clean Air Act amendments made it a bit easier for California to get a waiver. Also, those amendments allowed other states to adopt California standards instead of the federal standards, if they chose to do so. And we call these states the 177 states after the number of section in the Clean Air Act. So the market for cleaner cars expanded as other states opted into California Air Resources regulations over the following decades. So today in this webinar, we're focused on the most recent car and truck waivers. However, to complete the federal landscape, in 1990, Congress amended the Federal Clean Air Act to allow US EPA and California to control emissions from sources not operating on roads, such as locomotives, lawnmowers, and so forth. US EPA uses a very similar to the waiver process to authorize California to enforce CARB's off-road regulations. So, after losing all the political battles in Congress in the 1970s, the auto industry mounted numerous court challenges to limit the California Air Resources Board's regulations and to challenge the waivers granted by US EPA. However, the approval process of these waivers became quite routine, and scores of waivers were issued to the board, which is also known as CARB. And then CARB won virtually all of these court battles that were mounted by mostly the auto industry. So for the next 40 years, CARB's focus was to reduce emissions from car tailpipes. However, in 2002, then Assemblywoman Fran Pavley introduced legislation directing CARB to also control greenhouse gas emissions. And then CARB went ahead and issued those regulations. Again, flood of litigation, including a trial in federal court, but CARB won all of those in 2007. However, in late 2007, the Bush administration denied the waiver of preemption for these greenhouse gas regulations on the grounds similar to the ones that the auto industry raised, but then lost in court. So this waiver denial was unprecedented, and CARB immediately sued. So we'll jump ahead 18 months. So in May of 2009, a settlement was announced in the White House Rose Garden by President Obama with auto executives, California leaders, and US EPA attending. The agreement was that all the litigation would be dismissed. The waiver for the CARB greenhouse gas regs, which was denied by the Bush administration, would be reconsidered by the Obama administration. And then US EPA would proceed with its own federal rulemaking to reduce greenhouse gas emissions from cars. So during the Obama administration, CARB's initial greenhouse gas waiver for the Pavley car regulations was approved. And also, there was increased regulation of emissions, both tailpipe and greenhouse gases, for cars and trucks, both at CARB and at US EPA, in conjunction with the fuel economy standards, which were issued by the National Highway Transportation Safety Administration, known as NHTSA. So during the Obama administration, California routinely received waivers for its regulations. Okay, now we'll jump to Trump 1.0 administration. So there was an attempt during those 4 years to administratively reconsider the CARB's existing waivers for greenhouse gases and other pollutants for cars in a federal rulemaking. So this was called the SAFE rules. And the Trump administration then went ahead through NHTSA, the National Traffic Highway Safety Administration, and also US EPA to weaken all of the standards. So they went through a typical rulemaking process to issue these SAFE standards. But the target was greenhouse gases in the states. And there was a provision in these rules that said that all states, so California no exception, all states were preempted from issuing greenhouse gas standards because of another federal standard, the Energy Policy Conservation Act. So back in court, California, joined by other states and nonprofits, sued the Trump administration on the greenhouse gas and zero emission waiver rollback, and then commented and sued on the new federal regulations, which was relaxing the standards. So these cases were litigated through most of the Trump administration, and they were still active when President Biden was elected. And then those cases were put, for the most part, into abeyance and hold while it was being considered. So then what happened? CARB's zero emission and greenhouse gas waiver for cars was restored by the Biden administration. So you can see this flip-flop between the different administrations. And so that was restored by the Biden administration. So CARB was back in, back where it wanted to be. And eventually, during the Biden administration, more stringent federal standards for cars and trucks were adopted by US EPA and NHTSA. So I just want to note during the Biden administration, there was excellent collaboration between CARB, US EPA, and NHTSA to move ahead on this program. And I just want to acknowledge that Ann Carlson, as Joe already mentioned, was a key player for 3 years, first as general counsel and then as the acting administrator. So during the Biden administration, US EPA issued a number of waivers of preemption to California for a variety of regulations. And of course, there was a lot of litigation surrounding those waivers. But interestingly enough, it was the red states rather than the auto industry that was really pushing for the litigation during that period. And of course, some of that litigation is still ongoing. So what happened next? Unfortunately, the election in November 2024, and we're now in Trump 2.0. So I'm going to hand it over to Ann, and she's going to discuss kind of the current situation with respect to the waivers. Thanks.
Thanks, Ellen. That was super helpful prep for what I want to talk about. I often say in the context of Trump and environmental law that everything old is new again. But in the case of the waivers, that's really not accurate because the assaults on the waiver are actually coming from a different place. And so let me start with a conversation about the Congressional Review Act. So this is a super obscure statute that requires agencies to send to Congress new rules that they're going to issue. And then Congress has 60 congressional days, which is actually complicated to try to figure out what that deadline actually means, to disapprove them if they basically want to upend them. And so what you saw at the end of the Biden administration was a lot of effort to CRA proof its rulemakings by getting them finished before the 60-day end, that 60-day deadline, which again is not a straight 60 days. It's based on the congressional calendar. The waivers were never considered rules, and so they had never been submitted to Congress under any administration, certainly not the Biden administration, but not the Trump administration, not any administration. And that's because the Congressional Review Act actually defines rules. And it seems pretty clear that waivers are not rules under the Congressional Review Act and therefore not subject to its terms. However, that hasn't stopped the Trump administration from getting Congress to utilize this statute. So basically what happened is that Lee Zeldin, the administrator of EPA, sent to Congress 3 waivers, California waivers, some of which had been approved long before the CRA deadline, but kind of basically said, I'm starting the CRA process. And then Congress, despite the fact that waivers should not be covered under the Congressional Review Act, introduced a joint resolution. That's the process that you use to invoke the CRA that has to be voted on by a majority of both houses and then signed by the president. There were 2 important rulings prior to that time. One was from the GAO, which said that waivers are not covered by the Congressional Review Act. And one was from the Senate parliamentarian, who basically typically controls how the Senate procedures. And that's really important because if the CRA does not cover waivers, then the only way to undo the waivers is, and even this is contestable, is to bring normal legislation to the floor. And that, of course, would be subject to the filibuster. So it takes 60 votes in the Senate to get rid of the waivers. Again, even that, there's some arguments about why that might be unconstitutional, but let's put that aside. The Senate ignored the Senate parliamentarian and 3 waivers, the Advanced Clean Car 2 rule, the Advanced Clean Truck Rule and what's really helpfully called the NOx Omnibus Rule, just to get, talk about the acronyms that Joe led us off with, were all subject to the Congressional Review Act resolutions and have therefore been repealed by the Congressional Review Act. Interestingly, so you might ask, why are they doing this? I think one of the biggest reasons is something that Ellen alluded to earlier, and that is that the administrative process to actually re-examine and potentially revoke the waivers takes a long time. And in the first Trump administration, it took more than a year and a half. And in the meantime, the standards of EPA and California, importantly, remain in effect. And so this is a really quick end run around of traditional administrative procedure. It's also very likely illegal because, as I've already said, we've had the GAO, the Senate parliamentarian, and the language of the CRA itself say that waivers are not rules. They're more like formal adjudications. And we could talk about the details of that, but there's pretty strong argument here that the CRA is being inappropriately applied to revoke the waivers. So California, not surprisingly, has sued to overturn the CRA decision. There is, however, a pretty significant potential barrier to California succeeding in that lawsuit. And that's a provision in the Congressional Review Act that says, no determination, finding, action, or omission under this chapter shall be subject to judicial review. So the first line of defense by EPA and by the Department of Justice here is that a court actually can't decide whether California's waiver is a rule or not subject to the CRA. Stay tuned. We're going to see, we've already got one case beginning to consider that question. That's a separate case that Daimler brought seeking a preliminary injunction against a bunch of the California rules. The court just issued a preliminary injunction. This is in Daimler versus EPA, basically putting on hold a voluntary agreement that the trucking association had entered into to comply with California's clean truck rule, but denied the rest of the preliminary injunction. But part of the conversation in that case is about whether the waivers actually remain in effect because the CRA action was invalid, or whether the CRA action is binding and therefore California's waivers have disappeared. There's a couple of other problems with the CRA. One is that if Congress repeals a rule under the CRA, an agency cannot then adopt a substantially similar rule. That question, what is substantially similar, is a big, wide open one. So let's fast forward and suppose that there's a new administration in 2029 that is friendly to California waiver. Could California essentially adopt, say, the Advanced Clean Car 2 rule, but accelerate or change the dates? Because, of course, the implementation dates would be different. Is that substantially similar? Or does the state need to do something that looks quite different? We don't know the answer to that question. So that's the Congressional Review Act, and it's kind of a depressing story about the CRA. So I want to turn to another story that will seem depressing, but about which I have somewhat more optimism. And that is EPA's effort to repeal the endangerment finding, something that it did not do during Trump 1. And so in order to do that, I need to give you a little bit of history. I'm going to try to keep this short, but the history is important, I think, for understanding what EPA is up to. So I have to start with Massachusetts versus EPA. That decision in 2007 is, of course, the decision that said a couple of important things. One, that the state of Massachusetts has standing. That may be revisited. Two, that air pollutants under the Clean Air Act include greenhouse gases like carbon dioxide. And three, that EPA has to determine under Section 202 of the Clean Air Act whether greenhouse gases endanger public health and welfare when they come out of vehicles. Long story short is that the George W. Bush administration actually put together all the paperwork to find that, in fact, greenhouse gases, when emitted from automobiles, endanger public health and welfare. It did not actually issue the endangerment finding, but it tells you something about the strength of the science. It held on to the endangerment finding. Apparently, the Office of Management and Budget never opened emails that EPA sent, including the endangerment finding for OMB review. I believe Dick Cheney played a role in this as well. Figured it's worth mentioning him given his passing this week. And the Obama administration, as Ellen has already told us, issued it, granted the California waiver, did all sorts of things that put us onto a trajectory to begin to cut greenhouse gases and improve fuel economy in vehicles through model years 2025. We know what happened in Trump 1. Here we are in Trump 2. CRA gets used to revoke the waivers, and the administration has proposed to repeal the endangerment finding. And it's doing so on two grounds, one of which is that the science shows that greenhouse gases aren't so bad. Not clear that scientific finding is actually going to be made again in the final rulemaking, because there's been so much criticism of the incredibly shoddy science the administration relied on in its proposed rule, actually the science issued by the Department of Energy, that it may just rely on a legal argument. And the legal argument is basically the dissent in Massachusetts versus EPA, the dissent that was authored by Antonin Scalia. This is really getting in the weeds, but there's a reason that I'm going to get in the weeds for you here. So the reason that the EPA is proffering for repealing the endangerment finding is that pollutants under Section 202 of the Act, that's what governs automobile emissions, don't cover greenhouse gases. This section should only apply to local air pollutants, which is exactly what Antonin Scalia said in his dissent. He would have applied it to the entire Clean Air Act. Here, in the endangerment finding, it would apply to automobiles and also to utilities and to the power sector. So we may see a repeal of the endangerment finding. I think we're likely to see it. Rumors are that it would happen before the end of the year. There are thousands of comments that have been filed with EPA that the agency is supposed to respond to. We'll see how they respond if they actually do this before the end of the year. That's not an easy task. But assuming that they repeal the endangerment finding, we will see, I'm sure, immediate lawsuits. The bases of those lawsuits will depend on what happens, what the final rule looks like. Certainly, if the science continues to be relied on, the science, I should say, in quotation marks, that came from DOE, there will be a challenge to that as basically at abusive discretion or something worse than that. And we are likely to see a legal challenge arguing that what the basis that the agency is using is in complete defiance of Mass versus EPA. We may also see some procedural challenges depending upon what the final rule looks like, whether they've followed the Administrative Procedure Act, whether they've actually responded to comments, and so forth. But let's assume that the major basis is this legal basis. Why is EPA doing this? We've got a Supreme Court case that contradicts the basis for what the administration is saying supports its repeal of the endangerment finding. So my best guess is that they're seeking to get Massachusetts versus EPA overturned. And I think they have a good chance because no one in the 6 conservatives on the court was in the majority of Mass versus EPA. And in fact, Roberts dissented, of course, Thomas dissented, Alito dissented. And I think you could do the vote counting and assume that certainly Justice Kavanaugh would overturn Mass versus EPA. He indicated as much when he was on DC Circuit Court of Appeals. Neil Gorsuch, I think it's safe to bet would be in that group, and Amy Coney Barrett is probably the one who's less predictable. So that's terrible. The idea that greenhouse gases don't endanger public health and welfare seems absurd, and we can talk about that. But I want to talk about one potential silver lining if the administration actually goes down this path. There are several, and one has to do with nuisance cases. I'm going to put those aside, but could talk about those if you're interested. But the silver lining to me is that if the basis for the endangerment finding being repealed is that greenhouse gases are not covered by Section 202 of the Act, I think that opens up a strong legal argument that any state can issue regulations that regulate greenhouse gases. And that's because the preemption provision, all states are preempted except California, as Ellen has told you, but they're preempted only from issuing standards that cover emissions and pollutants that are covered by Section 202. So if Section 202 doesn't cover greenhouse gases, I think there's a good argument that states could just issue their own standards. And that would include California, and California could do so without receiving a waiver. Now, obviously, this would be litigated. We could speculate about what the defense might be, including an argument that Congress intends to have national standards and not 50 separate state standards. But it's also the case that the language of the Clean Air Act seems to say you can't regulate states' emissions that are covered by this part, pollutants that are covered by this part. And if greenhouse gases aren't covered by this part, again, I think states have a strong argument that they can issue their own standards. So this is a be careful what you wish for argument, I think, about the Trump administration's attempt to repeal the endangerment finding. It's not a surprise that the regulated industries that deal with EPA regularly seem not to want the endangerment finding repealed. I think they're worried about cans of worms being opened up, including this one and also on nuisance cases, which again, I can say more about. So stay tuned. There's endless litigation on all these questions. This is going to be a kind of moving target, not just this, but the CRA, all sorts of other cases as well. I do want to leave you, before we turn to questions and answers, with one optimistic note in addition to the silver lining that I've just outlined. And that is, it's really easy to despair that the withdrawal of the United States from everything climate, from Paris to the endangerment finding to the Inflation Reduction Act to all of the regulations that the Biden administration passed, is derailing our efforts to maintain lower temperatures, to cut greenhouse gases, to keep climate change to as least disruptive as possible. But the Trump administration cannot stop what I think is an inexorable move to a clean energy transition. That's including in the United States, but it's especially true globally. It is worth noting that renewable energy continues to be the cheapest form of energy. World solar and wind generation has now surpassed coal generation for electricity. Solar met 83% of global demand for electricity in the last year. It grew by a third from 2024 to 2025 in a single year. In the United States, solar is still growing despite efforts by the administration to cut it back. Battery storage is on the increase. We're seeing increasing investments in geothermal energy. Offshore wind is in bad shape. The administration has done everything that it can to really stymie that growth and to really stop that growth entirely. But we're moving ahead with renewable energy, especially as we see massive increases in demand because of AI. EVs are also moving in the right direction. They're not moving as fast as they should be. They're not moving as fast as they would be had Trump not been elected. But EV sales have grown in the United States and they are exploding globally. And that's largely because of the Chinese development of affordable, high quality electric vehicles that are being purchased around the globe. In China alone, almost all new sales of vehicles are electric. China's the biggest emitter of greenhouse gases. That's an extraordinary story. So I think it's worth just noting that, and this again harkens back to what Ellen said, there have been many political challenges in cleaning up our air. In the 1980s, we may not remember that Ronald Reagan rode to office in part on an anti-regulatory focus, specifically on the Clean Air Act. It was almost repealed or at least significantly weakened, but for the legislative acumen of Henry Waxman. It took a decade then to get the 1990 amendments to the Clean Air Act. The federal government did essentially nothing during the 80s on clean air. California led the way and continued to do so. So it's not the case that everything old is new again. I do think we're in a particularly challenging era that we've never faced before. But it's also the case that because of the efforts of states, NGOs like the Coalition for Clean Air, NRDC, Environmental Defense, Communities for a Better Environment, the leadership of CARB, the leadership of politicians in California, we got to keep the fight up. And I will stop there.
Thank you. And I've got so many questions. I'm hopeful that what I hear you saying is that the arc of fighting for clean air bends towards cleaner air in the end. I too agree that I think we're going to get there eventually. I guess the question is how soon. But one of the things, I mean, you've raised so many important issues, but maybe we should discuss first this idea of the revocation of the endangerment finding, and if we may be on the precipice of several states adopting their own standards. Isn't that sort of the reason we have a Clean Air Act in the first place, so that we don't have a whole bunch of different standards that everyone's adopting? And would this have the same consequences for industry that differing car standards have, where everyone says, well, let's just comply with California standards because it's the most stringent, and then we can sell our cars everywhere?
Yeah, so there's no question that the biggest argument against my argument is going to be we should have national standards. The question is whether the Clean Air Act actually says that with respect to greenhouse gases. And my argument is that it doesn't if you repeal the endangerment finding. So I think there's a couple of things that are worth noting. One is we're not going to have 50 separate standards. Wyoming and Delaware are not going to issue their own standards. I think it's very clear that that's the case.
But now Virginia may.
Virginia may, yes, Virginia may, New Jersey may. So, you could imagine either regional standards or, states banding together in the way that they formally do under Section 177, but informally could, right? So I suspect that there would be, if this argument actually has legs, there would be efforts to, try to do some of the stuff that was going on in the early and the Bush years, right? When you saw states kind of trying to band together, we got RGGI out of that. We had the Western Climate Initiative. I think you'd see some real state cooperation, in part to overcome that argument, but in part because it makes more sense, right? It does. You don't want to be a state out there issuing standards and having no vehicle manufacturer actually meet them. There are some counter pressures to the manufacturers. California has a market that happens to be big enough to be able to issue its own standards. Not many states can do that. I don't think we have to worry about Texas. New York is probably the only other one that, and in fact, in Ellen's history, when California got its waiver, New York was actually about to issue standards that were stronger than California in the mid 1960s. And that's in part what led to the preemption provision. I'm sure you'd see congressional moves to try to preempt states from issuing greenhouse gases, but it's a really weird argument to make that states can't regulate greenhouse gases, nor can the federal government. Right? That just seems completely odd. So I'd rather have a legislative battle over that question that would be opened up if the endangerment finding was repealed based on the theory that EPA is offering. But you're right that there's no question that this argument about national standards would be first, and it would be the front and center argument coming from auto manufacturers.
And but for the retirement of Ellen Peters, she'd be the one making this argument on behalf of CARB. I'm sure that when it comes to the Congressional Review Act and the provision that says it's not subject to judicial review, if you're misusing the act, right? The argument is you can't just exempt yourself from judicial review by using it any way you can. But Ellen, how do you feel about that? Do you think that how's this process going to play out? I know it's going to take a long time to get through the courts, but eventually it ends up before the Supreme Court, right?
Not necessarily. It definitely would go to the Court of Appeal. The Supreme Court, U.S. Supreme Court, can't take every case. You never know what's the most, what will capture their attention. Um, but in terms of the going back to the national standards, I
Mhm.
think, if you were, right now, in terms of the states that have already adopted the California car standards, it's about 40% of the market. So there's already kind of a coalition of states that are used to, they adopt them themselves, but they utilize the CARB standards for the different cars. So we would be talking about, purely greenhouse gas standards. And so that would be the zero emission vehicles and so forth. So I think that there would be a coalition. The other thing is that to actually set these standards, you have to certify them, you have to enforce them. And so I think that would be naturally the states that were interested in doing that would just defer to California because, we have the whole certification process. Manufacturers already have to get a certification from California. We did not. I keep saying we. CARB issued a August manufacturer's notice that says that you should just go ahead and follow the certification. We have our brand new lab in Riverside to test stuff. So I'm just saying, as a practical matter, I think that they would argue there's going to be 50 different standards, but I think the different states that are aligned to do that could basically form
Do it
a
in a
form a
reasonable way.
group, say they're going to do this voluntarily. We don't want to have the different standards. The one other thing that Anne alluded to when she was talking about was the market pressures. So we have the manufacturers, that's why during Trump 1.0, they actually entered into the framework agreement,
Hmm.
to continue to follow the standards, even though they were being, attempted to be rolled back by Trump. But there's just this global pressure to move to electric vehicles. And as Ann pointed out, it's getting cheaper to operate these. From a consumer's point of view, there's a bigger upfront cost. That should go down as, with all these new batteries and so forth. But it's cheaper to run. You don't have hardly any moving parts. You can just like never go to the, maintenance for your car. So once you get past the hurdle of the purchase price, very quickly, and I think it's like 3, 4, 5 years, you make it up in the other costs. So I think there's going to be a consumer push. There's the automakers push. If you go back to Trump 1.0, they were trying to roll back all the energy programs. And when it got to the U.S. Supreme Court took West Virginia versus EPA, but it was essentially moot. Everybody had already complied with the rules. It had just naturally the market moved. So I am hopeful that one of the pressures that's going on here is that regardless of what's going on in the courts, there will be some change. But I am an optimist. And I agree with you, Joe, that this whole notion that nothing could ever be reviewable, the executive could just take over everything. I mean, we already have our king inclinations going on now, but you know, it would just basically the administration could just exempt everything. So I think at some point, and the problem is the current Supreme Court. So I'm not being naive about that. It's going to be a huge challenge. But also the litigation lingers on. And so I think that, if we can flip the presidency at the next election, I think that's going to help again, which is what happened between Obama, Trump, Biden. So I think there's going to be there's other pressures going on that we don't necessarily have to rely on the courts.
Okay, we're getting through this really quickly. We have some good questions from the folks in the audience. I do wonder if there are any other tricks in the bag of tricks that California has to pull out at this stage, or is this what we see the process? I mean, from going forward, the challenge to the Congressional Review Act, seeing what happens with the endangerment finding, maybe reacting to that. Are there other things that are going to be happening that provide for some hope?
So Anne already alluded to the nuisance cases. So that's another kind. The states have police power to regulate for the health and safety. So there's that as kind of an underpinning of it. So I don't know. Do you think, Anne, the nuisance suits would be of use here in this setting?
So most of the nuisance suits are seeking damages for harms that already occur, as opposed to regulating emissions going forward. Although, you could ask whether those kinds of suits have a deterrent effect on emissions going forward. And the Superfund, climate Superfund legislation in Vermont is another one that's interesting to kind of follow. But California has a lot of tools at its disposal, and I don't think we should minimize those. What is it? Cap and
Invest.
invest. Sorry.
That's what it's called now. Yes.
I was about to say trade. Cap and invest, obviously just got extended. We saw a whole suite of energy bills passed. The state can offer tax credits to incentivize EVs. It can do a lot with fleets. It can do a lot with transportation. I know there's questions in the audience about reducing VMTs. That is not a federal issue. That's a state issue or a local issue, right? And so we shouldn't, there's a lot that can be done. I'm happy to see Governor Newsom going to Brazil to keep California, sort of as the man, as the leader here on states resisting what's going on at the federal level. You can do things on methane. I mean, there are lots of things the state can be doing. I would but be naive if to not acknowledge the damage the federal government is doing with respect to the waiver. The California Authority is the most effective authority we have. One of the stats that I think is always important to focus on here is that mobile sources contribute upwards of 80% of the conventional pollutants that the South Coast is trying to get under control to come into compliance with the 1997 standard, let alone the 20 ozone standard, let alone 2008 or 2015. The single best way to do that is to electrify the vehicle fleet, and that means heavy duty too. So there's no question that this is a blow and that California has a right to push back on the Congressional Review Act. But it doesn't mean we don't have a lot of authority, and we need to continue to use that authority. We need to do it in the context of very serious and important concerns by the public about affordability. It is great to see EVs coming down in price, for example, and they're coming down in price, and there are also a lot of models being issued. We no longer just have, giant SUVs or even Teslas coming down in affordability. We do have something like 112 new EV models. It might be a little lower now, given some of the changes in industry, but there's a lot that can be done, and we should continue to try to utilize every tool. We're not the only state that's doing that. Colorado's been super effective on methane. New York is I think going to lean in all over again on a lot of its climate measures. These climate superfund bills that are being introduced have actually passed in Vermont and New York. And that's a long answer, but the waiver is not our only tool for addressing these issues.
Okay, we need to get to some questions. I mean, we have to wrap up. We could have done this for a couple of hours easily, I think, and people could have gotten more CLE credit. But we promised to wrap up in 10 minutes or 11 minutes from now, so let's try to do that. I don't know if there's any of these questions in particular you would like to answer that have come in through the chat. I think one of the more important ones, Anne, is where do you pre-order the book? If you can tell people.
So I'm about to launch something that gives you options for pre-ordering. So I'll make sure Joe and Sherry and others that gets distributed. Please pre-order it. That would be great.
Okay. I see a
Coalition for Clean Air is in the book, not surprisingly.
Oh, wonderful. But
there's
I
a
think we need to
picture
do a
of Mark
book signing
Abramovitz.
sometime.
There's a
book
picture
signing on part of your tour. We're going to get
we'll definitely do a book event when it comes out, but you can pre-order it. Mark Abramovitz, there's a picture of him in the book.
Ah, yes. Wonderful.
So that's important. So
with us today.
I do hope you'll buy it. It's been a fun story to write.
Okay. Any of these questions in the chat that you'd like to answer here? I know we don't have time to do all of them. It would be nice if we could try to answer them all, but I don't think we're going to have time to do it all.
So I think there's a super interesting question about the degree to which we rely on litigation strategies given the hostility of the U.S. Supreme Court. So I'm going to pose that back to Ellen and Joe.
Don't ask me.
I think it's a really interesting question. Like, how much do we sue, and does suing sometimes result in decisions that are actually worse?
Well, I can tell you as an advocate, lawsuits are sort of a method of last resort because, they're expensive, they're uncertain, and if you can get what you need to get other ways, it's much better than having to file lawsuits. But we might not have any other choice here.
Well, I think we have to have the lawsuits. I don't think that can be our only tool, but we have to have them and for one thing, it slows things down. This is why the Congressional Review Act is worse because it went faster. But I do think that just the fact that the lawsuits went from administration to administration shows, that things will show down. And so getting a preliminary injunction. So I think for that reason we have to do it. The one thing we didn't mention is, um, you know, the Trump administration is actually doing things differently. For example, this whole Daimler thing on the clean trust, they're pushing back on other tools like these voluntary agreements. And so they had filed a lawsuit saying you folks, initiated an antitrust investigation. So they're being quite aggressive and this time around as opposed to Trump 1.0 in terms of new tools. So I think we have to then go back and use everything in our toolbox. I don't think we need new legislation in California. It's quite broad. So I think we just need to be creative in what we're doing. But I would not give up on the court suits because they have a place in there. The U.S. Supreme Court can't take every case. The Ninth Circuit and the DC Circuit, generally are good, and the district courts are building a factual record, and that's very helpful for later on when you're coming back to do it. Is not only the scientific report, but findings by district court judges after evidentiary motions for summary judgment or trials is going to be very useful in terms of, persuading folks to go down. And so once again, this maybe I'm being too
No,
optimistic.
I totally agree with you. I just wanted to hear you articulate it. I mean, especially, I think it's really important to just emphasize over and over again that the Supreme Court cannot take every case. And there are a lot of cases that are more wonky and technical that they may never take up. Just to come back to my own agency, a lot of the cafe litigation, which is really weedy, never goes to Supreme Court. Supreme Court doesn't seem very interested in cafe. It's much more interested in the Clean Air Act and EPA. So if we can prevail on some of that, there's some crazy stuff going on the cafe side, including the agency basically saying it's not, it's that the old rulemakings are illegal and therefore, essentially manufacturers don't have to comply the standards that we issued. So I could not agree more. And even on questions like the endangerment finding, if the Supreme Court's just going to whittle away at the power as it has with both West Virginia versus EPA and the Homer litigation, is it Homer or yeah, in any event, that we kind of need to know the bottom line. They're essentially they've been kneecapping EPA's authority for a while here. So in some respects, maybe we need clarity as opposed to just, let's just nickel and dime the agency and essentially wipe out their authority less directly than actually overturning
With the endangerment finding and maybe the potential overturning of Massachusetts versus EPA, is there a major questions issue there? Is that going to
yeah,
be raised? And that, I mean, we were
absolutely.
just hearing about it. Was it yesterday? They were
Yeah,
they
the
were arguing
tariffs.
over the tariffs,
Yeah,
major questions issue, and we got, you know, justices flip-flopping from side to side on that at the moment.
yeah. So
But
I mean, already the court twice in Clean Air Act cases has used major questions twice or three times to limit EPA's power. It's done so, basically to invalidate particular rules. The endangerment finding, we could see major questions. We could also just see a wholesale overturning, basically saying the language of the Clean Air Act does not cover greenhouse gases, air pollutants are not covered. Scalia had it right. We could see a wholesale overturning that doesn't rely on major questions, but major questions is lurking all over a lot of these cases. No question, especially because judges seem willing to use it to strike down things that don't appear to be particularly major sometimes. Um, particularly more conservative judges.
okay. Any final comments you want to make before we wrap up?
The one thing I want to say is that I think we need to be, and we've already said this before, but be creative. And so there's certain things. And so if you're operating the port and things are coming in through your entry, you might want to say, I want to have the trucks that are the cleanest. And they've already started that. But once again, there are ways that we can use the marketplace, or local government can do things as well. So I think that we should just be sponsor, a whole no bad idea kind of brainstorming as to what we can do going forward, because I do think that the public understands that exhaust diesel is a health hazard, is a carcinogen. And the more we get that out, the more people are going to start moving the public opinion. And then there will be, a demand from the marketplace on that respect, and from, public health officials. And that can be done, and is typically done at the local level. So I guess I would, I'm on all hands on deck, everything we should try, we should do everything. I think California's been great about setting money aside for the litigation. It's expensive, but we need to do it. And there's just no question about it. And we have great deputy attorney generals and great in-house counsels, writing these regs. So I'm cautiously optimistic. We just have to live through this dreadful period and turn it around.
Yeah, I would just add a couple things. I completely agree with Ellen. Not only do we need to be creative, but I think that the history of the waiver over for GHGs since the mid 2000s is not a pretty one. And it's one that is likely to be repeated if we see administrations changing political hands. So we see waivers granted, waivers withdrawn, waivers granted, waivers withdrawn or denied, back and forth and back and forth. And that's no way to run a railroad. That it does not send the kind of market signals we need to send. And so, to the degree that we can think about utilizing California authority that is not dependent on the federal government, we need to do that. And I know there's some really creative thinking going on right now about ICE engines and what to do with ICE engines that might kind of escape the need for a waiver. The second thing I would say is that we face really new air pollution challenges because of climate change, and that is nowhere more obvious than with respect to wildfires. And I know there's a lot of work being done on wildfires. The Clean Air Act is not really suited to deal with particulate matter from wildfires. In fact, it may, to some degree, get in the way of prescribed burning and so forth. So that's another place where I just don't want to leave a seminar on clean air without acknowledging that we have a huge problem with respect to wildfires. Of course, the damage, that the human loss of life, loss of animal life, loss of houses, et cetera, and the air pollution problems they cause, which are real and hazardous. We have got to be tackling. And again, that's the subject for an entire different seminar.
Clean air conversation webinar.
But it is an air quality issue.
We do have to wrap up because it's all right a minute before 11. For those of you who are attending for CLE credit, and I'm sorry for those of you who have asked those wonderful questions in the chat, we couldn't get to them. But for those of you who are attending for CLE credit, we're going to email you a certificate of attendance and the reading materials and an evaluation form. We ask you to return those to us. I want to thank our presenters, Ellen Peter and Ann Carlson. And what a fantastic presentation and conversation. Don't forget to buy Ann's book in April and come to whatever book signing event that we host at some point. Thank you also to the law firm of Greenberg Glusker for their assistance and support. And members of the Coalition for Clean Air staff, Jordan Brazil and Nicole Roberts. We can't do this without their hard work behind the scenes. Thank you for that. Thank all of you for attending and supporting Coalition for Clean Air. Just a suggestion, but Giving Tuesday is coming up on December 2nd. So please donate now or then, or now and then, to Coalition for Clean Air at ccair.org. May every breath that you take be a breath of clean air. Please stay safe and have a good day. That's going to wrap us up. Thank you. Goodbye.